Welcome to this introduction to financial disclosures for legal separations and dissolutions. If you're an existing client, you'll find some more detailed information in your online client portal under the folder Read Me First. There's a lot of confusion out there about why disclosures have to be completed and what exactly has to be disclosed. With this video, you'll have a better understanding and perhaps some resources that you can share with your partner or spouse as you begin your process. For couples going through a legal separation or a dissolution, California policy requires that full financial information be shared so that they can make informed decisions on how to divide community assets and debts and how to resolve child and spousal support and professional fees. The goal is to reduce the level of conflict. The higher the conflict, the higher the cost of the process and the longer it'll take to resolve. So the state policy is really to start these disclosures early. And it's not just what you think is community property. It is all types of property, separate and community. Definitions for some of the terms in your financial disclosure forms can be found in section 2101. There is some confusion when we talk about contingent interests. These are interests that you do not yet hold because certain minimum requirements haven't been met. A common example are companies that offer stocks to employees who have been with them for a certain period of time. If they leave before that time, they don't get the stocks, but if they stay, they do. These have to be disclosed. On the other hand, beneficiaries of revocable trusts, they don't have any interest in those assets until the trust maker dies, making it irrevocable, and now those assets are going to be administered to them. Until that happens, the trust maker can change their mind. They can change beneficiaries, they can sell the assets in the trust. When we talk about income, we're talking about from all sources. This is wages, this is rental income that you receive, dividends, trust funds that you receive, all of it has to be disclosed. And you do have a higher duty when you are in a confidential relationship, like a marriage. You have to treat the other person fairly, and it's different from a business negotiation. That's section 721. Those fiduciary duties continue until the asset or the debt is actually distributed. So until you transfer title to the car, for example. For spousal and child support and for professional fees, they continue until there is a binding and fully enforceable resolution to those issues. Preliminary and final declarations of disclosures are required by law. When we look at what needs to be disclosed, we look at section 2104 to start us off with our preliminary disclosures. Again, we have to use judicial counsel forms that will be signed by you under penalty of perjury. So failure to make full and complete disclosure and accurate disclosure could be a reason that the court could undo your agreements. You do need to disclose 2 years of tax returns in your preliminary disclosures out the gate. You do need to provide enough information to identify the assets and the debts, regardless of whether you think they're community or separate property. You need to complete an income and expense declaration. For petitioners, you need to do this and serve it on the other person within 60 days of filing your petition. If you're the respondent, you have 60 days from when you filed your response. Final disclosures are exchanged right before you're ready to resolve your case, either through trial or by agreement. If you were pretty thorough with your preliminary disclosures and not a lot of time has passed, it may just be a matter of updating the information. At this point, you need to disclose whether you think something is community property or separate and why. You also need to disclose values and balances for the assets and debts. And you need to complete your income and expense declaration. Again, you'll be signing these under penalty of perjury, so if you intentionally left something out or misrepresented, the judge can use that to undo your agreements. There are times I get couples who come in and say they've been trying to file their judgment and it keeps getting rejected and they don't understand why. Or I have couples who say, can we just get these agreements filed? It's really simple. When you file your judgment, it goes to a judgment clerk. That judgment clerk has a checklist to make sure that everything that should have happened before the judgment got filed has happened. If they are missing your preliminary disclosure proof of service, if they don't have on file the proof of service for your final declarations of disclosure or a waiver, your judgment will be rejected. Out-of-court processes like mediation and collaboration require participant cooperation and transparency when it comes to financial disclosures. As you can see, so does California law when it comes to legal separations or dissolutions. So what happens when someone isn't disclosing? You have a few options. You can ask the court to force the disclosure, or to fine the non-disclosing party, or to limit that person's ability to present evidence on a topic that would have been resolved had they done their disclosures. You can also ask the court to limit the ability to undo portions of your judgment only at the request of the person who completed their disclosures. I hope this information has been helpful to you in understanding financial disclosures in legal separations and dissolutions.